Welcome to the Rapport Review Podcast, your space for education, conversation, growth, and change. Sandy and Chip, with every brief episode, will take a moment to slow down, reflect, and explore counseling, its challenges, and victories that shape daily lives. Whether you're a therapist, a client, or simply someone on a journey of personal development, you're in the right place. Let's dive in, learn together, and keep moving forward. This is the Rapport Review Podcast.
Today, we are focusing on one of the most legally and financially punishing areas of law in the United States.
Driving while impaired.
Exactly. DWI, specifically here in North Carolina. And if you think this is just about, a court fine, you really need to listen closely. We're talking about navigating a complex legal landscape that involves immediate license revocation, a multi-tiered sentencing scheme, mandatory treatment, and financial penalties that can track you for half a decade.
Yeah, our whole mission here is really just to cut through all that complexity.
Yeah.
We want to give you a clear map, a guide to just how severe these consequences can actually get.
So what's the plan?
We're going to unpack the state's implied consent doctrine,
Yeah.
decode those incredibly detailed sentencing levels from A1 all the way down to 5, and explain all the mandatory administrative hurdles. I'm talking about the substance use assessments and the vehicle monitoring that can last for years.
And we absolutely have to start with the core legal friction point. This is where so many drivers get caught off guard.
It is.
We learned from our sources that in North Carolina, you have the right to refuse a preliminary roadside breathalyzer, that little handheld device, without an automatic legal penalty.
Right.
But, and this is the crucial part, the second you are placed under arrest, if you refuse the official chemical test at the station or a blood test, that refusal triggers an immediate severe license suspension.
And it's used as compelling evidence against you in your criminal trial.
That single distinction, PBT versus the official chemical test, that is probably the most crucial takeaway from this whole deep dive.
Okay, so let's start right there. Implied consent. What exactly is a North Carolina driver agreeing to the minute they pull out of their driveway?
Well, under NC General Statute 2016.2, you're giving what's called your implicit consent.
Implicit, right.
Just by operating a vehicle on a public road in North Carolina, you have legally agreed to submit to a blood alcohol concentration, a BAC test, if an officer has reasonable grounds to suspect you're impaired.
So it's the state's way of making sure you can't just refuse your way out of a test. Exactly. It prevents suspected impaired drivers from evading justice by just saying no.
But this brings up a key point. You do still have rights during that initial traffic stop before that implied consent hammer really drops.
That's vital. First, the right to remain silent. It's always there. You just have to provide your basic identification, license, registration.
And what about those roadside tests? The balancing, the walking the line?
The field sobriety tests, or FSTs, you absolutely retain the right to refuse those.
Now, they're subjective.
Right. They are very subjective, and refusal is often advised. Now, an officer can certainly use your refusal, plus other things like the smell of alcohol or slurred speech, to establish probable cause for an arrest.
Okay, so let's circle back to that preliminary breath test, the PBT, on the side of the road. What is a real practical reason for refusing that? Because it seems like if you refuse the FSTs and the PBT, you're just helping the officer justify arresting you anyway.
That is a great question, and it gets to the heart of the tactical decision you have to make right there. The utility of refusing the PBT before an arrest is all about protecting yourself from that immediate civil penalty. See, if you refuse the PBT, you do not get the automatic 1-year license suspension that comes with refusing the official test later on.
So it's a trade-off.
It's a trade-off.
Yeah.
You might increase your chance of being arrested, but you avoid that instant 30-day revocation and the big 1-year penalty, assuming you later submit to the official test at the station.
That separation is everything. But like you said, the moment you are arrested, the rules completely change.
Yes. This is the post-arrest trigger. Once you're arrested, you are formally asked to submit to chemical testing, breath, blood, or urine.
And if you refuse then?
The penalties are immediate, and they compound very quickly. First, you're facing an immediate 30-day civil revocation of your driver's license.
Right away.
Instantly. Second, if you're convicted of that implied consent violation, the revocation extends for at least a year. And third, on the criminal side, the prosecutor can stand up in court and tell the jury you refuse the test.
Arguing that you refused because you knew you were impaired.
Precisely.
Okay, so we've covered the immediate civil side, losing your license. Now let's get into the criminal side, how the court actually decides your punishment. And this is not simple. North Carolina uses a scale, and it weighs 3 specific kinds of factors.
It is incredibly detailed. It's why no two DWI cases are ever exactly the same. Sentencing is all about balancing grossly aggravating factors, or GAFs, against standard aggravating factors and mitigating factors.
And the outcome of that balancing act determines your punishment level.
Right. It runs from level A1, which is the absolute most severe, down to level 5, the least severe.
And these GAFs, the grossly aggravating factors, they're the real game changers, aren't they? If you have one of those, you're automatically bumped into the higher levels with mandatory jail time.
Oh, absolutely. What are we defining as a GAF? Well, a GAF represents the highest level of culpability or danger. A single one mandates at least a level 2 sentence.
And if you have 2
or more, or one of the most serious ones, and you're pushed to level 1 or even A1. And a huge factor here is recidivism.
a prior conviction.
A prior impaired driving conviction within the last 7 years.
And our sources were very clear on a unique point here. Each prior conviction counts as a separate GAF. Why is the law structured to compound it like that?
It's designed to punish repeat behavior exponentially. If you had, say, 2 different DWI convictions in the last 7 years, you don't just have a sentencing history.
You have 2 distinct GAFs.
2 GAFs on the record for this new offense, and that automatically pushes you up to a level 1 sentence, which means much longer mandatory active jail time and a way higher fine.
That is a critical distinction. What about the other major GFs, the ones that focus on endangerment?
Well, the law takes serious injury very, very seriously. Causing serious injury to another person is a GAF. Also, driving while your license is revoked because of a previous DWI.
Another GAF.
And here's one that, on its own, mandates a level 1 sentence. Driving with certain vulnerable passengers. We're talking a child under 18, a person with the mental development of a child, or someone with a physical disability who can't get out of the car without help.
So endangering a vulnerable person immediately triggers that second highest sentencing level.
Immediately.
And it's so important to remember that even if you avoid all the GAFs and land at the very bottom, level 5, there is still a mandatory penalty. This isn't just a slap on the wrist.
Absolutely not. If you land at the lowest severity, level 5, where your mitigating factors substantially outweigh the aggravating ones, you are still facing a mandatory sentence of 24 hours of active jail time or 24 hours of community service.
Plus a fine.
Plus a fine up to $200.
Yeah.
The law removes a judge's discretion to just, levy a small fine and send you home.
So if there are no GAFs, the scale just balances between aggravating and mitigating factors. Can you give us an example of how that shifts the sentence?
Sure. If aggravating factors outweigh the mitigating runs, you'll land at level 3. A common aggravating factor could be a really high BAC, say 0.15 or more, or just highly reckless and dangerous driving.
And to get down to level 5?
To get down to level 5, you need your mitigating factors to dominate. An example would be slight impairment just from alcohol with a BAC that's not over 0.09. And this is a big one. Voluntarily submitting to a substance abuse assessment and actually doing the recommended treatment is one of the strongest mitigating factors you can have.
And finally, the extreme end of the scale. When a DWI stops being a misdemeanor and becomes a serious felony, habitual DWI.
Habitual DWI is triggered if a driver has 3 or more prior impaired driving convictions within a 10-year period.
And that bumps the whole thing up to a Class F felony.
It does. And that carries a mandatory minimum active prison sentence of 12 months. No probation, no suspended sentence. You're going to prison. And it results in a lifelong revocation of your driver's license. That's the top of the pyramid.
Okay, let's move from the criminal sentence over to the administrative penalties. Let's talk about the DMV and license revocation. The lengths are tied directly to your conviction history, right?
They follow a very clear progression. For a first DWI offense, no priors, the revocation is typically 1 year.
1 year? And if you have a prior?
If you have 1 prior DWI within 3 years of the current one, that penalty jumps dramatically to 4 years.
Wow, 4 years.
And if you have 2 or more prior DWIs, with at least 1 happening within the last 5 years, that results in a permanent revocation.
Permanent. Okay. Regardless of the sentence or how long the revocation is, everyone convicted has to complete one specific bureaucratic hurdle before they can ever even think about getting their license back.
The mandatory DWI substance use assessment.
Yeah.
It's required for everyone, whether you want to restore your license or even just get a limited driving privilege, an LDP. It involves an interview and a structured questionnaire at a state license facility.
And it costs money, of course.
Of course. It's a state-mandated fee of $100, which you have to pay when you schedule it. And this is important. The assessment is only valid for 6 months. If you don't start your treatment or education within that time, you have to pay and do the whole thing over again.
And that assessment is what determines the level of intervention you need, from education to, like, intensive treatment.
Yeah.
This connects back to what we talked about in the beginning.
Exactly. The assessment places you into levels I through V. If you are a first offender with a lower BAC, say 0.14 or less, you might just get level IDWI education, which is about 16 hours.
But what if you refuse the test?
If you refuse that post-arrest chemical test, that implied consent violation, the law penalizes you here too. That refusal automatically results in a minimum of level 2 short-term treatment placement.
So even if your BAC was low, the act of refusing means more mandatory treatment time.
That's right. The refusal itself bumps you up a level.
So for people facing those 4-year or even permanent revocations, is there any hope of getting back on the road sooner?
There is a conditional restoration process, but it is very strict. You have to meet very monitored criteria. For a 4-year revocation, you can petition after 2 years. For permanent, it's possible after 2 or 3 years, but the requirements are substantial.
Like what?
Well, the 2-year path, for instance, requires you to prove 12 months of sustained abstinence before you can even apply. And that's often verified through a continuous alcohol monitoring device, a CAM.
And after all that, the time, the treatment, there are still fees.
Always. There's a mandatory payment at the DMV desk. The DWI reinstatement fee is currently $167.75, plus the standard restoration fee of $83.50. So even when you've done everything right, it still costs a couple $100 just to re-enter the driving world.
Let's talk about the hardware. The requirement that becomes a reality for a lot of drivers, the ignition interlock device, or IID.
This thing essentially turns your car into a portable breathalyzer.
That's the simplest way to put it, yeah.
It's wired right into your car's ignition system. You have to provide a clean breath sample that registers below the limit before the engine will even start. If the sample fails, the vehicle will just burn out. It won't turn over.
So what are the main triggers in North Carolina that mandate you get one of these installed?
There are 3 main ones. You have to install an IID if you were convicted with a BAC of 0.15 or more.
Okay, the high BAC.
Right. Or if you have any prior DWI conviction within the past 7 years. Or, finally, if you were sentenced to that severe aggravated level 1 DWI.
And how long does this thing have to stay in your vehicle?
It's long-term, 1, 3, or even 7 years, depending on the offense. And critically, that clock only starts on the day your license is actually restored.
And the limit it's set to is pretty tight, right?
Very tight. Either 0.04 or, for more serious offenses, 0.000 tolerance.
We read that the rolling retest is a huge source of anxiety. For listeners who haven't dealt with this, what happens if you miss that random retest while you're already driving? Does the car just shut off on the highway?
No, thankfully not. That would be a major safety hazard. But the device will log the failed or missed test as a violation, and it triggers immediate consequences inside the car.
Like what?
It'll typically start flashing the headlights and sounding the horn continuously until you either pull over and shut the car off or provide a clean sample. It makes it impossible to ignore, and it logs that event for the monthly data download the monitoring company requires.
And all the costs for this, the installation, the monitoring, that all falls on the offender, correct?
Entirely. Installation can be $70 to $150, and then you're paying monthly calibration and monitoring fees, usually between $60 and $90 for the entire time.
For up to 7 years.
For up to 7 years. It is a recurring, non-negotiable expense.
Let's talk about what might be the single most expensive long-term consequence. This goes way beyond court fines, treatment fees, and IID costs.
The auto insurance penalty.
It's a devastating financial hit.
It really is. Currently, a DWI conviction assigns 12 insurance points, which is the maximum allowed under the North Carolina system. This results in about a 340% increase in your annual premiums.
340%.
And that alone is crippling for most people. But there's a major regulatory change coming.
That's right. The time frame for that 12-point penalty is about to nearly double.
This is critical for anyone in North Carolina to know. Effective July 1st, 2025, those 12 insurance points will now stay on your driver's record for a mandatory 5 years.
Up from 3.
Up from the previous 3 years.
5 years of paying 340% more for car insurance. That means the total financial cost of a DWI, even a low-level one, is now calculated over a much, much longer period. It's not a one-time thing. It's like a sustained mortgage on your insurance policy.
It creates a tremendous cumulative financial burden, the state is making a very clear statement here.
Which is
that DWI consequences are not just handled by the court and then forgotten. They are tracking you administratively, financially, and technologically for at least 5 years, sometimes longer, after that conviction date.
So this deep dive has really shown us the systematic way North Carolina tracks and penalizes impaired driving. You have the immediate civil revocation for refusing a test, the compounding criminal sentencing through the GAFs, the mandatory assessments that funnel you into treatment.
Then years of required IAD monitoring.
And now this newly extended 5-year insurance penalty, it's a whole system.
And if we look at the ultimate consequence, even in those severe cases where a driver finally earns back a conditionally restored license after a permanent revocation, say after 3 years of abstinence and monitoring, the story isn't over. The DMV has the authority to impose additional conditions.
Like what kind of conditions?
Time or geographic limits on your driving. And those restrictions can legally track that driver for up to 5 years after the date of the conditional restoration.
It's just a reminder that the responsibility of getting behind the wheel carries a severe long-term legal footprint in North Carolina, one that lasts well after the court date is over. Something for you to deeply consider before making that decision.
Absolutely.
We'll see you next time.
Thank you for joining today's Report Review. If this episode connected with you, inspired you, or gave you something meaningful to reflect on, I'd love for you to share it with someone who might need it too. Be sure to subscribe so you never miss an episode. Until next time, stay grounded, stay growing, and take good care of yourself. This is Antonio, signing off from the Report Review Podcast.